Okay, so very good morning, and this is the last lecture of the 7th week, and in this lecture we are going to talk about the legal issues which may arise out of performance management system and processes. You remember before that we talked about reward, that how reward is to be linked with performance management, and in the process we have seen that if you are not going to follow a process which is accurate, which is standardized, which is uniform in nature, then this kind of problem may come up. So, we have to see that how to avoid lawsuits, how to ensure that we maintain equity when it comes to rewarding for performance, and we also avoid lawsuits that might arise out of rating errors and all kind of things. So, in this context it is very it is very important to understand what could be the various law related issues in performance management. Why it is important? Because if there are going to be lawsuits and other kind of things, then we are going to spend lot of money on these kind of things, and this could be a problem for the organization in terms of its reputation and brand image. So, now we are going to discuss something that is related to reward in terms of its equitable distribution, in terms of its standardization, in terms of its uniformity when it comes to rewarding employees for their performance. So, it is very important to understand these issues. Okay. Now, we need to ensure that when you are going to develop a performance management system and you are trying to link it with the reward, make sure that it is legally sound. Legally sound means that you need to follow two things, that is the processes for distributing rewards, okay, is standardized. It means that you need to adopt a standard process, so that people feel that when they are being rewarded, okay, the principles of justice is being followed. Okay. It means that you are going to follow a standard process to reward employees, right. And similarly, when it comes to evaluating performance, you also follow a standard process, that is rules and procedures for evaluating performance are standardized and uniform. So, that you do not make any mistake in evaluating employees, because evaluation is linked with the reward. Okay. So, if your evaluation is having certain errors, then there might be certain problems, right, and then the evaluation is going to be faulty, and if the evaluation is faulty, then any decision that you are going to take on the basis of performance management in terms of rewarding employees or giving them any opportunities intrinsically and extrinsically, that is going to be inaccurate, right. So, you need to standardize the process of evaluation, you also need to standardize the process of reward, and you need to ensure that you are going to follow the same process for everybody, right. So, you need to apply it to everyone, okay, and make sure that the system is equitable, fair and just, so that nobody is going to complain against the system, and any decision that is taken on the basis of performance management, so far as related to any administrative decisions or even developmental decisions, right. And that is why you need to avoid such legal issues in the future. Now, when it comes to taking legal actions for poor performance, you have we have examples where the contract of the employees may be terminated, or he may be asked to leave, or there could be certain administrative decisions like not giving increment, or stopping the individual. Okay. So, all extending the probation period. Okay. So, there could be lot of issues related to poor performance, and sometimes companies also take legal actions for poor performance, right. And if you are going to take it, and if a system is not standardized and uniform, then there could be legal actions against the company. So, you need to ensure that you have a proper performance management system, right, and if you have it, you can avoid lawsuits and also reduce the risk of human rights cases, because if you are going to say contract the terminate of an employee, okay, and he is going to file a lawsuit that you have not been taking care of a proper standard process for evaluation, and though you have performed well, but that it is being rated as poor, then there could be lot of problems, right, because this is also not only related to performance, but human dignity. Okay. So, the standard process is that if somebody is not performing well, so you give him a warning, okay, and if he is going for any kind of say policy breaches, he is not following rules and regulations, he is engaged in some kind of misconduct or having certain performance problem. So, instead of taking direct legal actions, it is always good to communicate his performance or tell him what he is doing, so that he can correct him. So, it is always good that you give him a chance to correct himself, so that his performance remain good, and make sure that your performance management system has a process of giving feedback. So, that if he is doing something which could be considered as a policy breach or misconduct, okay, a poor performance can be corrected at a later stage. So, it is always good to identify performance related problems, right, and tell communicate employees your concern that your performance is not good, or you give him feedback in such a way, so that he takes certain corrective actions, and also help and facilitate the process, and make sure that he is going to improve his performance. So, you have a performance improvement program for those employees who are not doing well in terms of performance, so that they are able to correct their performance, right. And despite repeated warning, okay, and putting him into performance improvement plan, if the person is still not able to perform well, then you have no other option but to terminate the contract. Okay. So, make sure that you have exhausted all possible efforts before you are going to terminate the contract of the employees, and you have tried your best and still the person is not able to improve the performance. So, that should be the last resort for an employer, and then before taking that, he must see to it that he tries his best to improve his performance, but despite all efforts that is made by you in terms of training or other coaching interventions, or putting him into performance improvement plan, if the person is still not able to improve the performance, but then you do not have any other action, but to see that the person is not going to work in the organization. So, suppose for any reason and the person finds that injustice has not been done, and he moves to the court against any against the contract termination or any error that you have made in the process or system, then the role of the court is very important. Okay. But before they go to the court, you also have a grievance handling process within the system. Within the framework of rules and regulations, you try to solve the problem, because if the matter goes to the court, then you become a party, and then the court will decide what is to be done. Okay. And when the court is going to conduct the look at the employee's performance, he is not going to simply look at it in isolation that the person is not able to perform well, but he would also the court would also try to identify those factors which has led to unsatisfactory performance. Okay. Because the person may not be responsible for poor performance, there could be other factors. Okay. If you remember, we talked about performance analysis. Suppose there could be external environmental factors, staff management, lack of resources and equipments, right. If that is the reason and the person is not able to perform well, then the role of the court would be different. He might dispose in favor of the employees, and you have to take him back, right. So, it is very important to ensure that internally you try to resolve the issues, having your own mechanism for resolving all kind of disputes, including related to the performance, so that this kind of situation does not arises. Because if the matter goes to the court, then the court is going to look into this, and they are going to ensure that the justice is done to the employees. If there is any injustice is done, then it is done. So, make sure that your system and process standard uniform, right. You communicate him about it and make sure that he is able to take any action to improve his performance, and if that does not happen, then that is the last resort, as I told you. Now, when we are talking about the role of the court and when they are going to decide about the fate of the employees, okay, then there are certain factors which are very important, like the context and circumstances under which the person is going to perform, okay, and then he is also going to look at the length of the service and also the nature and character of employment. So, these are the factors which would be considered by the court before disposing of the matter. So, what we are going to discuss now is that what are the factors which are very important, which could be considered by the court, like context and circumstances of unsatisfactory performance. Because as I told you that when you go for performance analysis, you try to identify those factors which could be responsible for poor performance, right. So, when the court is going to examine the matter and they are going to say that why this person has not been able to perform well, and because of which his job is at stake or he might be terminated from the service or have been terminated from the job. Okay. So, he is going to look into several factors like what is the type of unsatisfactory performance and how severe it is. Okay. If he has been performing very poorly consistently, then it could be severe. Okay. But if it is once upon a time case, then he may not he may overlook at it. Okay. Maybe there could be situational factors, other contextual factors which might have been responsible for his poor performance, and then the individual cannot be attributed or he cannot be blamed for poor performance, right. So, another issue that is related to this is duration or frequency of incidents of poor performance, whether he is consistently performing poorly despite making all the efforts by the employer or putting him into performance improvement plan or not. So, if the case is so that the person is consistently performing badly or his there is an incidence of unsatisfactory performance from the employees, then the court is not going to rule in the favor of the employees. And but if it is a just one such case, then the thing would be different, right. Now, another issue is that whether the employee has been communicated about poor performance and whether you have taken adequate care in terms of interventions, whether it is training, coaching or other kind of things, to see that the employee is able to improve his performance, right. So, before you terminate him, you must give him a chance to improve upon, and that is why this warning is given, so that the employee is able to improve his performance, right. Now, another issue is that whether employee accept the responsibility for poor performance or not. In many cases, it has been found that employee do not accept the responsibility for the poor performance, they attribute it to external factors. It could be related to the supervisor, the environment, the top management and other things. Okay. Now, the management has to prove that poor performance is due to unsatisfactory due to the internal attributes, maybe the lack of knowledge and skill or the motivational interest of the employees, right. Otherwise, the court may decide in favor or against depending upon the case. So, if the employee has accepted the responsibility for unsatisfactory performance, then you will be in a better position, right. And whether he is not able to demonstrate any kind of improvement in his performance, or if there is a gradual improvement in his performance, then the case would be different, right. So, whatever is the case, the court is going to decide depending upon the merit of the case and the context and the circumstances under which an employee is going to perform his job. So, it is very, very important to examine these things before the matter goes to the court, because court is going to look into all these issues. So, if you remember in the beginning also we talked about two kind of performance which are responsible for your outcome, that is task performance and contextual performance. Okay. So, the contextual performance is very, very important. So, you need to look into the context which is going to facilitate task performance, okay. And that is why it is very, very important to examine contextual factors which is related to the environment to ensure that whether these contextual factors were responsible for poor performance or not, and how to ensure that these barriers are got rid of, so that the employee is able to perform well. Or if it is due to task related factors, then how are going to improve his knowledge and skill, so that the employee is able to perform well. So, moving away from these contextual and circumstances which might lead to poor performance, another factor that is to be considered is the length of service of an employee, right. Okay. If it is an isolated case or misjudgment or unsatisfactory performance of a long term employee means the employee who has been working in the organization for a number of years. Okay. So, it is going to be less likely to provide a just cause for dismissal. You can just simply cannot dismiss because the person has been serving in the organization for a longer period, and in some cases his performance is not satisfactory. Okay. But if it is a short term employee, the person is on tenure or contract and he is not able to perform, then the case would be different. So, length of service is also considered before a decision is taken by the court, either in the favor of the employer or in favor of the employees. So, when you are going to terminate employees, you also see that what was his long term performance, whether he has been consistently performing well, or there are few stray incidents of cases where the person has not been able to perform well. Okay. If that is so, so the employer has to be sympathetic and try to improve his performance, okay, so that it is consistent. And but if it is a case of say short term employees, a contractual employees, okay, and he is going to work for a very short period, or he has worked only for a few say months or years, then the case would be different. Okay. So, these are the issues which could be looked into by the court. Now, apart from length of service, another important factor is the character of employment. Okay. What is the position that is held by the employees in question, right? But say for example, if it is related to the management cadre, okay, and if he is continuously breaching the policy or is, intentionally or unintentionally, then the case would be different. Okay. But dismissal for the cause is not likely to be upheld by the court in case of lower level employees whose performance issues have less impact on the employer, because if you look at the senior level employees and if they are doing something wrong, it is going to significantly impact the performance of the organization, right. But if it is a lower level employees and he is not able to work or is not able to perform well, then it has a less impact on employer in terms of performance of the organization. Okay. So, both the cases could be looked into two different ways by the court, okay. Because in case of a lower level employee, the court may not support the employer, but in case of a higher level employee, it might support, because of his performance the organization is going to suffer huge loss, and there is not a significant contribution by the employees towards the organization. So, those two cases are different, and that could also be considered when the court is going to take a decision. So, what we discussed so far is what is the role of the court and how the court is going to decide such cases which might be related to the poor performance. Now, see, if you look at the trend and the record of performance related issues, the lawsuits related to performance management, it is either related to discrimination of some form or unjust dismissal. Okay. Discrimination in the sense when you are going to discriminate employees, okay, either to bad rating or bad compensation or discriminating in compensation and these kind of things, or you have dismissed the contract of employees, okay, without being fair to him, right. So, unjust dismissal and discrimination, these are the two kind of charges that is framed against the employees, okay, which may invite lawsuits against the employer, right. So, to protest against these kind of lawsuits, it is very important that you have a system which could be legally defended in the court of law, right. So, when we are talking about a legally defensible performance management system, make sure that it is based on valid job analysis. It means the task and other things are derived from the job description of the employees, okay, and make sure that it is clearly linked with the performance of the employees and it is communicated to the employees. Okay. So, you go for a proper job description, okay, communicate it to the employees what is expected from him. So, the standards are known to him, he knows what is to be done, because that becomes the criteria for the evaluation, right. Now, include both the behavior as well as results in the performance evaluation, right, instead of rates, and then rates to rather than traits or multiple raters. Okay. So, when you are going to use behavioral results, okay, instead of rating him on traits, it is always good to go for multiple rating. So, that you get a more comprehensive picture, and you also go for self appraisal, where the person is going to evaluate himself, because he would be the best person to see what is the performance level, right. And if you go for these kind of things, probably you can avoid some kind of rating errors if you go for multiple raters, right. Similarly, you also train people who are going to rate, so that they do not make any error in the rating, right. And then whatever rating is made by the superior, immediate superior of the employees, that is being reviewed by the senior level managers. Okay. And then also have a appeal mechanism for the employees. What I mean to say by appeal mechanism, the person is not satisfied with the rating of his performance, he can always make an appeal to higher level managers or senior level authorities in the organization. Okay. So, that the matter can be internally resolved within the organization, because if the matter is not going to be internally resolved within the organization, then the person might be forced to file a lawsuit in the court of law, and that could create a problem, because then there you have to defend everything and justify why you have dismissed or terminated the contract of employees. Okay. So, these are the two major issues, that is dismissal or and discrimination. Now, what we are going to discuss now is some of the legal principles which are going to affect the performance management system. The first one is employment at will, right. Now, you know that when the contract is formed between the employer and the employees, a formal agreement related to job, it suggests that the employer and employees can end the employment relationship at any time, and there is a period, contract period could be of 1 month or 3 months, within which you can communicate to the employees that you are not required, and it is communicate to the employees. Similarly, employees can also communicate to the employer that they are not going to work in this organization, right. So, this is what we know as employment at will, where both the employer and employees can decide about the fate of employment, and this would be accepted by both the employers as well as employees. Now, negligence, when you have a performance management system and it is documented in manuals or contracts or other materials, you make sure that you are going to implement it as it is, right. So, there should not be any kind of negligence on the part of the employer as well as employees, because both of them are aware about the employment contract, which needs to be followed by employer as well as employees properly, right. For example, suppose if you receive what she believes is an unfair performance evaluation, then you can always go and complain to the higher authorities. Then you have to see that whether the system was implemented properly or not, whether the rating has been done properly or not, otherwise the individual is going to challenge the system, and this could create a problem. Similarly, there are cases related to defamation. For example, if you are going to disclose untrue, unfavorable performance information, and it is going to damage the reputation of the employees, right. So, if employees find that you are disclosing information related to his performance to others, then it will be called defamation, right, because you have given false information during the performance evaluation, right. So, you need to avoid these kind of things, so that you are not going to defame employees for his performance during the evaluation. Another issue is misrepresentation. Disclosing untrue favorable information, right, because it is also going to cause harm or effect to the employees, right. Suppose there is an employee whose reward is there, and he is being recommended by a former employee who was actually terminated because of poor performance. Then the employer is guilty of representation, because you are going to act on behalf of an employee who has already poor performance, who has been terminated by the organization, right. So, basically it is a case of misrepresentation. Another issue is related to unintentional discrimination, where performance management system try to discriminate employees. So, when it comes to rating or evaluation, for example, sometimes women receive lower performance rating than the men. So, it is a clear case of what you call discrimination, and this is known as unintentional, because knowingly you are doing it. So, it might have an adverse impact on the employees. Then illegal discrimination, where you go for disparate treatment, right, where the employer, the managers are, when they go for rating, they are going to assign scores differently to various employees, on those factors which are not a performance related criteria, right, such as race, nationality, color, ethnicity, or the national origin. So, if you are using these considerations for evaluation, then you are illegally discriminating an employees, because you are not going to treat him or evaluate the employees or rate employees based on his performance, but you are considering other factors which are not a part of your evaluation criteria. Moving further, So, these are the laws which are affecting the performance management, okay. And many countries including India have passed laws prohibiting discrimination based on race and ethnicity, sex, religion, national origin, age, disability, sexual orientation. Okay. Now, the Indian government has also passed lot of law related to that. We are not going to look into all the laws, but some of the major laws which are very, very important, which is related to performance management. One is the Payment of Bonus Act, that is very, very important. Now, if you look at the Payment of Bonus Act, it basically says that okay, you have to give bonus to people employed in establishment depending upon the profit or on the basis of the production or productivity, right. Now, this law says that employees drawing wages up to 10,000 are eligible for minimum 30 days work performed by employee during the accounting period, right. And the payment rates and calculation of bonus is also decided, right, which is going to be roughly 8.33%, right. And then the maximum that you get is 3,500 rupees, okay, even if you are drawing more or less than that, and the time limit is also defined. Okay. So, when you are going to pay bonus depending upon the salary that you are going to give to the individual, you ensure that it is at the rate of 8.33%, right. So, that you are not going to discriminate employees based on the performance, because bonus is a kind of reward that you are providing to the employees, and you are not going to discriminate employees so far as giving the bonus is concerned. Okay. So, whatever rules or regulations which have been decided by the government, you have to follow it in providing the bonus. Okay. And if you look at the Payment of Bonus Act, it clearly specifies the rate and how the bonus is to be calculated, and you have to use these rates and calculation whether you are working for in the private sector or the public sector organization. Okay. Another important act is equal remuneration. We are not going to discriminate people based on their sex, right. So, if you look at this Equal Remuneration Act, it aims to provide for the payment of equal remuneration to men and women workers, right, and also prevention of discrimination on the ground of sex against women, okay, especially in the matter of employment. Okay. So, this is a very important act. So, you are not this is related to discrimination in terms of employment. Then there is the Minimum Wages Act basically, because Minimum Wages Act is provided to skilled and unskilled labor, and since being this being in the concurrent list, anyone central or state can form rules that what would be the minimum wages, right. And these wages actually vary depending upon the sector, state, region or occupations, right. Even if you look at the Indian constitution, it has also defined a living wage, that is the level of income for a worker which ensures a basic standards of living, including good health, dignity, comfort, education, these kind of things, right. So, you need to see that you are going to follow the Minimum Wages Act, and if you are giving less than that, as decided by either the center or the state, then it invites legal action against the employer. So, these are the three major acts. There are other acts related to disability, related to the sexual discrimination, these kind of things, which may also affect the performance management system of the organization. Now, if you look at the characteristics of a legally sound PM system, okay, we have to look into the role of the three parties, that is the organization, the management and the employees separately. Now, when we are going to look at the characteristics of the legally sound performance management system, you remember we talked about some of the rules and regulations from the government, what is desirable by the organization and what is desirable the managers and the employees. Now, when we are going to discuss about this legally sound performance management system, we have to look at the role of the different stakeholders in the process, right. So, to start with, we will talk about the role of the organization. Okay. What is the role of the organization? Okay. So, when we say that we are going to have a performance management system which could be legally defended, what does it mean? It means that you are going to have a performance management system which is transparent, which is objective, which is accountable, okay, which does not discriminate on certain criteria, right. People know what kind of performance management system is, what is the criteria, what are the goals and standards that is to be achieved, okay, and it is communicated to the employees. So, it is the responsibility of the organization that whatever performance management system is in place, it is explained to the employees so that they know that this is how they are going to be evaluated their performance based on the criteria which is decided well in advance, right. And organization also ensures that they have a formal grievance handling mechanism within the organization to ensure that if there is any complaint against the evaluation, the process or the reward related to the performance, there is a formal process to appeal to the higher authorities. Okay. So, the system should also include a formal appeal process. Next is that you also need to have a standard uniform process for all the employees in a given job, right. So, that when you are going to evaluate, there is not variations and you do not make any error in the evaluation process. Okay. And it also has process which is able to detect potentially discriminatory effects of biases or abuses in the system. So, that people know that okay, what are the issues that may crop in related to the biases, okay. And if managers are going to use these biases, they are detected in the process or in the system, right. Let me give an example for say if you are going to follow a say 360-degree mechanism for evaluation. Now, there could be different raters which are going to evaluate your performance, okay. And then you try to look at the consistency across raters so far as the criteria of performance is concerned, that how everyone or all the stakeholders have evaluated. Say for example, if the supervisor is biased and he is trying to discriminate employees and he is rating low or poor while others have rated him high, so he would be caught in the system. So, you need to develop such a system which is more comprehensive, where you are able to detect any kind of discrimination or biases that could be there in the system, and it is the management is able to detect it or the organization is able to detect it. Moving to the role of the management, make sure that the managers are not going to make any kind of intentional or unintentional errors. Okay. So, they need to be trained formally that how they are going to manage the performance of their employees, how they are going to rate, how they are going to link it with the reward. Okay. So, the kind of process that they are going to adopt, they should be communicated about it. Okay. And then when they are collecting information related to the performance, they are collecting it not just from one source, but they are going to get it from different sources, okay, to ensure that the rating is unbiased. Okay. Similarly, you also need to ensure that you have documentation for the performance of the employees, so that you are able to defend it in case it is required, okay. And you are collecting information from the employees and related sources, so that you get more reliable information, because it is first hand information, and if it is not reliable or first hand, then it could be questioned at a later stage, right. So, management has the responsibility to ensure that they collect data from different sources, that are trained, so that they are not biased, and they are collecting data from first sources. And finally, we have employees, because that they are equally important in the process. Okay. So, employees must be communicated what are the criteria against which they are being evaluated, and for each criteria what are the standards. Remember, you talked about accountability, standards, right, and the criteria against which the people are going to be evaluated. So, each and every employee, depending upon the job requirement, is communicated what the performance dimensions and standards against which they are going to be evaluated, and you clearly communicate and define this to employees that yes, this is the criteria against which you are going to be evaluated, and make sure that it is linked with the job which they are doing, okay. And employee have the knowledge and skill to do it. So, you are going to evaluate on job related criteria, and also that is under the control of the employees, because if it is externally influenced and because of which the employee performance is not good, then you cannot blame or attribute it to the employees. So, make sure that those factors which are within the control, only that is being rated for performance, right. And then they should be given continuous feedback about their performance, and if there are any deficiencies, they must be communicated, and they also should be provided an opportunity, so that they can correct it. And if there is a problem, they should be allowed to voice their concern, especially related to the evaluation or the review, and the management must treat them with courtesy and dignity throughout the process, so that employee understand that yes, they are valued, they are part of the system, and the performance management system is objective, fair and just, and if you are following these principles, probably you will be able to develop a legally defensible performance management system, and you can avoid lawsuits and these kind of problems in the court. Thank you very much.